10 million Americans are reportedly gone, arrested, processed, and stripped of their firearms and freedoms. Not by a dictator, not by a foreign invader, not by some stealthy midnight coup, but by a Supreme Court ruling decided 9-0. Let that figure sink in. Not 5-4, not 6-3, along the familiar partisan lines the public has grown accustomed to reading like a weather map. 9 justices, liberal and conservative, appointed by both Democratic and Republican presidents, all looked across the mahogany bench and said yes. Reports from law enforcement, advocacy groups, and emergency motions, filed in 17 states, indicate the country faces what may be the largest mass arrest in its history. The mainstream media has largely buried this under sports and celebrity news, leaving the scale of the event largely unseen. According to these sources, the Supreme Court's 9-0 ruling triggered the arrest of 10 million gun owners nationwide. If you personally own a firearm or know someone who does, this concerns you directly. The ruling itself warrants intense examination. A unanimous decision is extremely rare. In recent decades, the court reaches unanimity on roughly 20-30% of cases, usually technical and non-controversial. When the court is unanimous on a case involving the Second Amendment, the most politically charged provision in the Bill of Rights, it is not a minor footnote. It is a seismic event, a moment likely to be studied in law schools for decades, either as a model of constitutional clarity or a cautionary tale about how republics falter. The decision upheld a federal regulatory framework that reclassified a significant category of commonly owned firearms and firearm accessories as prohibited under existing law. This change came not from new legislation passed by Congress or a democratic process with voter input, but through judicial and administrative reinterpretation of the law. All 9 justices agreed it was constitutionally valid. In practice, this means millions of Americans who legally purchased and were required registered firearms, who stored them safely and never used them to threaten others, suddenly found their property redefined. Overnight, legal possession became illegal. Compliance became criminal. The highest court endorsed it with no dissent. Legal scholars defending both gun rights and civil liberties describe the ruling as breathtaking, unprecedented, and dangerous. The concern is not ideological. It is about the retroactive criminalization of lawful behavior. If this can happen to gun owners today, the precedent could extend to others tomorrow. Rights are not selectively enforceable. When one falls, the entire framework weakens. That 9 justices found no disagreement suggests either the legal argument was unassailable or that political and institutional forces pushed the court toward consensus, defying expectations about the current divided state of American jurisprudence. Beyond legal theory, the human cost is immense. The 10 million Americans reportedly caught in this enforcement action are not fictional extremists. They are neighbors. A veteran who returned from 2 tours in Afghanistan kept a rifle in his closet to manage the nightmares and retain some sense of control over safety. A single mother in rural Pennsylvania purchased a handgun after threats from her ex-husband went inadequately addressed by local law enforcement. A retired Detroit police officer legally owned the same firearms he once carried on duty. A Texas farmer relied on a particular RIF. This is not a blue state issue. It is not a Democratic administration targeting red state gun culture. Reports are coming from Georgia, Montana, Ohio, and Arizona, states where gun ownership is deeply tied to culture and daily life. The arrests are happening everywhere. The people affected believed they were following the law until they were told otherwise. We are now entering the political fallout phase. What is happening, or not happening, in Washington reveals much about American governance in 2026. Republicans, long defined by Second Amendment absolutism and using gun rights as a fundraising and mobilization tool, have been remarkably quiet. Where are the full speeches, the emergency press conferences? Where are the senators who received millions from gun rights groups standing at a podium declaring this cannot stand, promising to fight it with every legislative tool? Most are absent. Some release cautious statements of concern without committing to action. Others hide behind procedural language, insisting proper channels must play out, as if 10 million arrested constituents can wait. On the other side, Democrats show nervous celebration. Even those who have advocated strongly for gun restrictions recognize that retroactive criminalization without new legislation could backfire politically if the public understands the full implications. The mainstream media, as usual, flattens the story, presenting it either as a gun control victory or a constitutional defeat, depending on editorial lean, without probing deeper questions. Who benefits from this social disruption? What happens to politics when 10 million people are criminalized simultaneously? Is this enforcement sustainable, just, or operating within consent of the governed? The constitutional crisis is not yet being named as such. The Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. 4 words, shall not be infringed. Not shall not be infringed unless the Supreme Court unanimously decides otherwise. Not shall not be infringed except when administrative reclassification retroactively bans a previously legal item. Shall not be infringed. Period. Constitutional law is complex. Anyone claiming the Second Amendment is simple either misleads or has not studied the century of case law surrounding it. The Supreme Court's 2008 Heller decision affirmed an individual right to keep and bear arms while acknowledging certain regulations are allowed. The 2022 Bruin decision reinforced individual gun rights, establishing a historical tradition test for evaluating firearm regulations. In 2026, this unanimous ruling appears to navigate both precedents, resulting in 10 million Americans being arrested. Scholars on the right call it a betrayal of Heller, and their Second Amendment rights are in legal limbo, but they are not sitting in a cell. That distinction matters because the full human impact is diffuse and difficult to capture visually. It does not look like the mass incarceration images most are familiar with. It looks like a man in Ohio who can no longer pass a background check for a law enforcement job. It looks like a woman in Tennessee whose professional license is under review due to a pending federal charge. It looks like a family in Nevada navigating the federal court system with a public defender juggling 400 other cases. Federal prosecution at this scale produces suffering that is quiet, grinding, and largely invisible to those outside the system. That is precisely what makes it a powerful instrument of government control. The most pressing question remains. What comes next? Not legally, not procedurally, not in terms of motions and appeals, but for the country itself. What happens to the social contract between the American government and the nearly 1/3 of households that legally own firearms? What happens to the already fragile trust between citizens and institutions? The reality is uncomfortable for both sides. Those supporting strict gun regulations did not achieve a clean victory. They may have won in court, but they may have sparked something far more destabilizing than the gun violence issue they sought to address. Criminalizing 10 million people at once, including veterans, retired law enforcement, and rural Americans who have never interacted with the justice system, does not create safety. It creates a society that is angrier, distrustful, and convinced the government sees them as enemies rather than citizens. Gun rights advocates, Second Amendment organizations, and ordinary owners who feel betrayed must also confront the reality that decades of absolute opposition to any regulation or safety conversation contributed to conditions that enabled a unanimous Supreme Court decision. Neither side emerges unscathed. Both share responsibility for the country reaching this moment. Ordinary Americans cannot wait for permission. Sitting passively in front of a screen and hoping for action in Washington is not sufficient. The most powerful step now is to demand answers persistently and by name. Call your senator, attend town halls, visit congressional offices. Ask directly, what are you doing about the 10 million Americans arrested under this ruling? What legislative response do you propose? What emergency measures are planned? What is your timeline? Make them answer. Washington depends on exhaustion. Political machines rely on the public being too tired, busy, cynical, or demoralized to continue pushing. They count on this story being replaced before the... Please, leave your thoughts about this content in the comments below. Thanks for watching. See you in the next one.